And tonight we're looking at Measure 114, Oregon's gun control law that voters passed almost a year ago. That's gone just about nowhere. Measure 114 has been tied up with legal challenges since it passed with just 50.6% of the vote. Earlier this year, a federal judge ruled that the Measure 114 is constitutional. That decision, though, is being appealed. And today, closing statements wrapped up in a state lawsuit in Harney County. That's where a judge will decide if Measure 114 meets the standards of the Oregon Constitution, and where lawyers have been battling it out over claims of self-defense and public safety. Evan Watson joins me now. And Evan, first update us on where things are today and what we're really talking about here with Measure 114.
Yeah, so first thing to know, that judge says he has about 2 months to make a decision in this case, but he hopes to share his ruling sooner than that. And honestly, this case seems primed for an appeal as well, regardless of what the judge decides. Measure 114 has 3 main components, to remind you. It would require a permit to buy a gun, expand background checks in Oregon, and ban large capacity magazines holding more than 10 rounds. Gun owners and their lawyers squared off against Oregon Department of Justice lawyers today, debating case law, self-defense, public safety standards, and whether there's a legal place for large capacity magazines in our communities.
Public safety is what defendants want this court to consider. However, this case is not solely about public safety and instead requires that this court find both that there's a public safety benefit and that the benefit is accomplished without infringing or even unduly burdening the right to bear arms.
The fact that detachable magazines and automatic fire technology were eventually used for civilian purposes cannot, according to the Court of Appeals, quote, bootstrap these weapons into personal defense weapons so that they come within the constitutional protection.
So it's interesting what we hear there. These are similar arguments to arguments we've heard around the country in these cases, right?
Right, and precedent plays a big role here as well. That argument of the question, what did the founders intend compared to how firearm technology has evolved? Both sets of lawyers cited judicial cases dating back 150 years, and that led to one of the more entertaining moments of the day. A lawyer representing the gun owners talking about the Oregon coast being a little vulnerable.
The possibility that Oregon may need her armed citizenry is ever present in an ever-changing and tumultuous world. Oregon, being a coastal state, is an obvious location for a potential invasion. 165 years ago, and building on the Second Amendment enacted decades before, the first citizens of the state of Oregon chose that a well-armed citizenry would be needed to protect this state. But this idea is not so outdated as defendants would suggest. The court heard evidence that still today, Oregonians are assisting law enforcement by protecting not only themselves, such that they don't need law enforcement, but also assisting law enforcement.
Yeah, really interesting argument that he gave there. Now, Evan, we know that 10 states do have some similar permit to purchase laws, and 11 states have similar bans on large magazines. So how did the state argue, hey, we should be able to do this?
By focusing on how they believe these changes would help public safety, which is often the argument in these cases. In the federal case, the judge actually agreed with the Department of Justice lawyers, saying large capacity magazines are not commonly used for self-defense and permit to purchase is constitutional. Here's the perspective on that from both sides.
Case law does not allow for an absolute prescription on any arm, regardless of the public safety benefit. There is no level of public safety benefit that can avoid this prong.
We disagree. The permit to purchase provisions do not prohibit acquisition of firearms. They require individuals to establish that they are not a danger to themselves or others and pass a training component.
All right, so we do not have a final decision yet. The judge says this could be coming in the coming weeks, right?
In the coming weeks. He has up to 2 months, he said, until the lawyers will really start pestering him. But he hopes that will come sooner. And it's largely expected that even that decision is going to be appealed. I was saying earlier that we can hardly call Measure 114 a new law anymore. It was passed back in last November. But of course, it hasn't taken effect, and we're not even close to that final say just yet, even if the challenges are moving forward step by step.
Yeah, still some more decisions, some final decisions to come in all this. All right, Evan, thanks so much.
You got it.